For more insight on the Presidential Election Petition Court judgment, let's speak to a legal practitioner, Evans Ofeli. Well, let's quickly get your reaction now to that 12-hour marathon judgment of the Presidential Election Petitions Court, because already both the PDP and Labour Party have rejected the judgment.
Well, one thing this judgment have taught us is that if you must go to court, you must have proof of your claims. If you look at it before the build-up to the judgment, there was a lot of issues on all eyes being on the judiciary. People were optimistic, or some were pessimistic, but the fact is that there were tensions here and there as to what the judiciary or what the outcome of this is going to be. But when the judgment was read, it was quite clear and logical that the parties who went to court, the petitioners, could not prove most of the claims that they brought before the court. If you allege that there were irregularities, you must be able to prove how that irregularity affected the outcome. And that is what we call substantial non-compliance under the law. When you look at the issues of 25%, it fell because by the interpretation of the Court of Appeal, Abuja is just like any other state. If you look at Section 299 of the 1999 Constitution as amended, you find that there. And if you also go further to look at the issues of double nomination from the other party, it was a pre-election matter that was not brought before the Federal High Court as it should by law. So when you project further, you find out that witnesses that were called by the Labour Party, they had issues during cross-examination. Some of the witnesses, even the expert witnesses, could not stand the fire of cross-examination and the rest of that. So proof is very important. We would say litigation is evidence-based. You see, litigation is not about settlements. If you approach the court of law for the purposes of adjudication, you must, as a matter of necessity, prove your case. And you must succeed on the strength of your case and not on the weakness of the defendant's case. And that is exactly what has turned out here. The judgment was robust, was far-reaching, was scholastic, and was one that took into consideration deep legal reasoning. However, there were some other part of it which were not very clear as it relates to front-loading of the witness statement of subpoena witnesses and the other witnesses, which I find really a little challenging. I have my reservation for that, and I'm still studying further on that area based on the two authorities that were cited by the Court of Appeal. But by and large, the judgment is one that has given us certain hope. I mean, the judiciary is not just there for the sake of it. The judiciary is there to dispense justice.
All right, Mr. Ofeli.
The truth is that the options...
Yes, Mr. Ofeli. I would like us to talk about how this would impact our jurisprudence going forward. Because, for instance, one of the issues that have been on the front burner is that of the IREF portal. A lot of concerns had arisen before now as to why the election results were not uploaded in real time, which was the promise by INEC. But now the Petitions Court has ruled that the Electoral Act prevails in this matter.
Yes, the Electoral Act says that the mode of transmission shall be determined by the INEC chairman, by the commission. Okay, so that itself, even though a lot of conspiracy theories are here and there that it was malicious that they did not upload it and not transmit as promised, that is, if you look at that promise is encapsulated in the regulation of INEC and not in the Electoral Act. So it is not a statutory mandatory provision of law. And that is why the court interpreted it in the way it did. For those who are clamoring that you must transmit, what we have to do is to go back to their amending the Electoral Act to that effect to reflect it. As it is right now, there is no mandatory compulsion on INEC to act in that manner, and that is how the court ruled, because that's how it is in the law. It's not by the sentiment of the promises they made and they could not fulfill the promise. Well, it is morally not imbalanced. It's morally imbalanced to make promise and not keep to the promise. But legally speaking, where there is no statutory provision expressly stating that you must do this as a matter of necessity, then it will fall on the wayside. It becomes no issue. So I think the judgment is fair. There are options of appeal open. I mean, the option of appeal is open to the aggrieved parties who are not satisfied with the judgment to approach the Supreme Court and to do the needful. But I would say that Nigerians should at least, having seen the reasoning of the court in this issue, now we know that the reasoning of the court is different from the reasonings you have on the social media, on the newspaper and the blogs and all that. All these platforms, the court will never consider it in granting judgment. The court will only rely on the judgment, the evidence before it. The evidence before it is what the court will use in reaching a decision. And that's exactly what the court has done. And we have said this over and over and over again, that the fact that a lot of people in the public, they are swayed towards a position or swayed towards a candidate or swayed towards, does not mean that that is what the court will do. If the parties so aggrieved are unable to prove, like in one of the cases, there was an allegation that some votes were taken from a political party and given to the other political party. The court was of the view that how many votes was involved, how many was taken, how many did you score, how many was given to the other party, how many, and there were no particulars to that effect.
Indeed,
so if
indeed.
you don't have particulars to that effect, if you don't have particulars to that effect, how do you expect the court to use your oral testimony that is not backed up by evidence to reach a decision?
All right,
that
and
will
considering
lead to miscarriage of justice.
Yes, Mr. Ofili, and considering the thoroughness of this judgment and just how long it took for it to be delivered, what would be your call really to the other political parties in this matter? Yes, indeed, they have the opportunity to appeal the same judgment, take it to the Supreme Court. But what really would be your word to them at this time?
My word to them is that they should listen carefully to their respective counsel in the matter under reference and consult adequately before taking the next step. They've said that already, that they are going to look at the judgment and then they are going to consult widely before they take the next step. I think that is the way to go. It is their case, okay, whether they decide to end it here or decide to take it to the Supreme Court, it remains their case. But the most important thing here is that it is better they look at the judgment itself very proper, do all the consultation needed. If they find the need to go to the court of the Supreme Court, fine. If they do not find the need to move further, fine. So the most important is that we have peace and we have tranquility in Nigeria, and democracy is thriving in the country as it is.
Evans Ofili is a legal practitioner. Thank you so much for talking to us on TVC News at 1.
Thank you.